It's my pleasure to moderate the next session entitled Islamic Bioethics Through the Lens of Islamic Tradition. My name is Taha bin Hassan Abdul. I am the Harvard Islamic Society chaplain, a lecturer at the business school of all things at Harvard University, and I wear a couple of other hats. Among them is that I sit as an ethical reviewer on a number of Sharia-compliant financial advisories around the world. So that's particularly interesting for me, as we'll be discussing, among other things, the roles that traditional Muslim jurisconsults play in the issues that are before us today and tomorrow. We have a truly interesting and beneficial set of presentations ahead of us. I will introduce each one of the speakers, call them up, and rather than taking time at the very beginning, we'll have approximately 15 minutes for each one of them, and then if we're blessed to have some time for questions at the end, we'll take a couple of questions and then wrap up. I believe that we'll begin with Professor Sherman Jackson. Professor Jackson is known to many of you, known to most of you. He is the Arthur F. Thurnow Professor of Near Eastern Studies, Visiting Professor of Law and Professor of Afro-American Studies at the University of Michigan. Professor Jackson received his PhD from the University of Pennsylvania and has taught at a number of institutions, including the University of Texas, Austin, Indiana University, and Wayne State University. He served as the executive director of the well-known CASA, Center of Arabic Study Abroad in Cairo, Egypt, and is author of several works, including Islamic Law in the State, the Constitutional Jurisprudence of Shihabuddin al-Qarafi, on the boundaries of theological tolerance in Islam, Abu Hamid al-Ghazali's Faisal al-Tafriqa, Islam and a Black American, looking towards the third resurrection, and his last major work, Islam and the Problem of Black Suffering. Professor Jackson has been featured in the Washington Post, and Newsweek on Faith, in the Huffington Post, and other media outlets, and has been named recently as one of the 500 most influential Muslims in the world by the Royal Islamic Strategic Studies Center in Amman, of something which he takes to heart. He's also been recognized by Religion News Writers Association, Religion Link, as one of the top 10 experts on Islam in America. It's our pleasure to receive him and to hear from him. His presentation entitled Controversies in Islamic Law and Ethics. Professor Jackson.
Thank you very much for that interesting introduction. I've been given sort of the unenviable task of trying to address a very rich, broad, and indeed ongoing set of controversies in the history of Muslim thought. And I've been asked to do that in all of 15 minutes. So what I'm really going to try and do is sort of cut to the heart of issues that I think very much inform the intellectual and the religious universe within the context of which Muslims presently wrestle with ethical issues. And I want to do that in such a way that gives us a sense of how we have arrived at this particular point in Muslim moral discourse. Basically, I want to divide the history of Muslim moral discourse into 4 overlapping and competing stages. And by that I mean that there's never been a single point in Muslim history where one particular perspective actually prevailed to the absolute exclusion of all others. Rather, one or another may have been predominant at a particular time and place, but they always had to compete with each other for preeminence. And these 3 stages, or 4 stages, are actually the stage of moral objectivism, and I'll explain what all these fancy words mean in just a minute. The second stage is what is commonly referred to as theistic subjectivism. The third is traditionalism, or the sort of common sense school. And then finally, we come to modernity. Now, the stage of moral objectivism was actually one of the earliest stages of moral discourse in Islam. And this particular approach to morality was based on the idea that the moral character of things is actually inscribed upon creation. And therefore, all we need to do is to read creation, or nature, if you like, correctly. And if we do this, we can know what is good and what is evil. Moreover, because morality, according to this particular approach, is inscribed upon the material world, we can know good and evil independent of revelation. Revelation, in other words, does not bring anything new to moral discourse. In fact, all it simply does is uncover what is actually already known. And so what we have here is an approach to moral and ethical discourses that basically argues that Muslims, and I want to be clear that this was a development within the body of Islam, that Muslims can essentially know good and evil independent of revelation. Because revelation does not bring anything new to that discourse. All it does is to uncover what we would normally discover ourselves if we could read creation with the proper set of prisms and sensibilities. And just for those of you who want to sort of zing somebody at a cocktail party or something like that, this particular approach was the approach of a movement called the Mu'tazilites. The Mu'tazilites. And it flourished for a number of centuries to different degrees in different parts of the Muslim world. In the Central lands, it sort of declined around the 5th century of the Muslim calendar, the 11th century of the Common Era. In other parts, such as Central Asia, it went on as long as the 9th century of the Muslim era, the 15th of the Common Era. Now, this Mu'tazilite approach, or the approach of moral objectivism, was vehemently rejected by another approach, and this was the approach of theistic subjectivism. Basically, theistic objectivism argued that creation, or nature, however you want to look at it, is morally dumb, that it cannot and does not speak to us. As such, all claims that are made about morality are really simply attempts to impose our own human agenda upon others through the aid of enlisting creation or nature as our fundamental argument. In other words, what we really call good or evil is simply what we perceive to serve or not to serve our own subjective interests. Moral judgments, in other words, originate in us and do not inhere in nature. And therefore, there is no real moral ontological index that undergirds any moral claims. Now, this school was quite serious about this, and one of its major representatives actually went so far as to say the following. And this is the extent to which they were opposed to the idea that when I make a moral claim to X, that all I am doing is reading creation. They were insisting upon the fact that we must recognize the extent to which I am trying to superimpose upon creation a judgment that actually comes from within. And he says, one who has no religion will deem his affair with another man's wife to be a good thing, counting his conquest of her a bounty. And he will consider the act of one who exposes his breach to be evil, and term the latter an evil-doing snitch. A religious person, meanwhile, will term the latter a good-doing guardian of community standards. And each of these persons will simply describe these actions according to his or her interests. And that is, again, that there is no objective moral index out there in creation. He goes on to underscore the fact that it is we, human beings, who bring these judgments to creation. Quote, take the statement, justice is good, lying is evil, and present it before the court of primordial reason, which affords a priori knowledge. Then imagine that you have not lived with anyone, nor mingled in the midst of any religious community, and imagine that you have not been ingratiated with any tradition, that you have not been refined by any upbringing, or primed with the teachings of any teacher or guide. Then see if you are able, thank you, reach a point where these judgments appear to be so matter of fact to us that we can mistake them for actually being represented in the things in nature that we seek to superimpose them upon. But this is all fallacious according to this second position. And in fact, the only reliable source of morality, therefore, since nature or creation is not a reliable source, is actually that which transcends nature and society, i.e. revelation. For that reason, the theistic subjectivists argue that revelation is the only reliable source for moral judgments. And by moral judgments, they are talking about not what we understand to serve or to contradict our own interests. However, what we are talking about is what God will reward or punish in the life to come. And what they're arguing is that there's only one way that we can know this, and that is through a reliance upon revelation. And this was the position of the school known as the Ash'arites. The Ash'arites. And it was quite a dominant position, certainly within Sunni Islam. And by the way, and perhaps Imam al-Qazwini can speak to this as well, when I talked about the decline of Mu'tazilism, I was talking about the decline within Sunnism. All right? It has a different historical trajectory within Shiism. All right, the third position that we come to is actually the sort of common sense approach. And I'm not satisfied completely with this particular designation, but the traditionalist school basically sort of argue that, look, it really depends on what kinds of judgments we're trying to make. Obviously, if you ask, is it a good thing to save a man who is drowning, we can all know that independent of revelation. In fact, we may even be able to go on to the point to argue that God will actually reward us for saving a man who is drowning. When, however, and I'll wake everybody up early in the morning, it comes to a moral judgment on something such as polygamy or the shares of inheritance, what they argue is that these things can only be known by revelation. And so it depends on what kind of moral issue we are talking about, whether or not our judgments can be based on reason, and reason is always in and of itself socially and culturally informed, even historically informed, or we are totally dependent upon revelation. And the common sense or traditionalist school is opposed to either extreme of saying that everything or nothing is based on revelation, or everything or nothing is based on reason. All right? And they seek to navigate a sort of middle road. All right, coming to modernity. Modernity has, in some ways, confronted Muslims with a very unique and somewhat, you might want to call it difficult, a set of circumstances. On the one hand, modernity itself would seem to be more a reflection of the Ash'arite approach. And by that, I mean that modernity dispenses with the notion that there is any natural index of morality. This is one of the fundamental premises of Enlightenment thought. Good and evil, therefore, go back to Hobbes and people like that, it's very clear. Good and evil, therefore, are not references to some kind of ontological index of morality, but rather what we as a society negotiate. And preferably this negotiation takes place through sort of democratic processes. But there are no ontological references for morality, and there certainly are no transcendent references for morality. And therefore, what we as a society deem to be good or evil is going to be that which emerges out of this ongoing negotiation that, as I said, presumably takes place within the context of a democratic process. Now, on the other hand, this is on the one hand, and we're all sort of confronted with this. On the other hand, there is a sort of mood, I would characterize it as, among modern Muslims to find ways to escape some of the weight of the cumulative legal tradition or Sharia, which itself is grounded in certain historically and culturally informed presuppositions from the past. And one of the modes of trying to escape some of this weight is to incline back towards a Mu'tazilite mode of moral reflection. In other words, this is part of a more general move away from law, i.e. as the presumed repository of do and do not do with its degree of finality that is itself grounded in the fact that this law comes from Scripture and has divine origins. There's a general move towards a more loose and I think sort of discretion-based moral conversation that seeks to be more sensitive to what reason unaided by revelation might be able to inform us of in terms of our moral judgments. And so in that sense, we get a move back towards the Mu'tazilite approach. And again, I want to be clear that neither of these have emerged as dominant tendencies. But this is a part of what informs the way that modern Muslims tend to discuss issues of morality. And I think that at the present, we're still in a sort of a transitionary stage. And I think that over the next generation or two, especially here in the West, we may be moving closer to something either on the lines of a consensus or sort of a running détente where you really have more than one a Muslim approach to the issue of ethics, but both of them are informed by this sort of historical trajectory that I've tried to lay out here in my 15 minutes. Thank you very much.
Thank you very much, Professor Jackson. Our next speaker will be Shaykh Musa Furber, who is a traditional jurisconsult, that is a mufti, and a specialist in Islamic law. He was born in Massachusetts and raised in Portland, Oregon. He majored in linguistics at Portland State University with emphasis on computational linguistics and cognitive science. And after graduation, he went to Damascus, where he completed an intensive 4-year study of traditional Islamic disciplines, including Quranic studies, prophetic traditions, ethics, law, and jurisprudence, advanced grammar, and prophetic biography, seerah. Upon completion of that program, he continued his studies with scholars in and around Damascus, who authorized him to translate and teach. He later relocated to Cairo, Egypt, where he entered and completed an intensive program mentorship in the issuance of legal responsa, fatwa, at the Dar al-Ifta al-Misriya under the direct supervision of Shaykh Dr. Ali Jum'a, the Grand Mufti of Egypt, who authorized him to issue legal responsa. While at Dar al-Ifta, he served as an unofficial researcher and English translator for the Dar. He currently resides in Abu Dhabi and is a lead legal researcher at the Taha Institute for Islamic Studies in Abu Dhabi. He will be giving us a presentation entitled How Sunni Jurists Respond to Bioethical Dilemmas. Shaykh Musa Furber.
Assalamu alaikum. Thank you for having me here. One moment while I try to acquaint myself with this. This talk will focus on how Sunni jurists respond to bioethical dilemmas. It will cover the historical role of jurists in answering questions of an ethical or legal nature, the knowledge and skills employed by individual scholars, and how these are applied. It will also cover the emergence of group ijtihad councils and their role in addressing emerging issues. This talk also aims to respond to an oft-repeated claim that jurists do not or cannot address contemporary issues. This presentation explores two main questions. How do Sunni jurists respond to contemporary bioethical issues? And what is the context in which Sunni jurists work? And I emphasize that this concerns Sunni jurists because I do not know how the Shiite tradition works, and I have no authority or expertise to speak for them. We will leave this for the next speaker. To answer these questions, we will explore the classical and contemporary literature written by Sunni jurists concerning legal rulings and methodologies, both in general and restricted to bioethical issues, and the current practice of how jurists apply legal rulings to cases presented by individual petitioners. And as those who have looked at these subjects can tell you, 25 minutes isn't enough for all of this. So if I go fast, try to keep up with me. And if I slur a little bit, I'm very, very jet lagged. So a little bit of charity, please. We need some background. Muslims consider Islamic law to be comprehensive and based on defining legal sources that are then explored and mined by scholars. Muslims often say that Islam is sound for every time, place, people, and circumstance. The Quran and prophetic teachings clearly indicate that it is obligatory to clarify the legal ruling for all human actions, endeavors, and deeds, so that Muslims can be sure about their status with respect to permissibility, validity, and the ensuing consequences. Scholars who explore the overall objectives of Islam often do so in terms of realizing public interests, known as al-masalih al-am, or warding off harms and obtaining benefits. Since interests and harms vary from one age to the next, there will always be a need to assess warding off harms and realizing public interest. The 13th century Shafi scholar Izz-ad-Din Abdus stated that all legal rulings can be reduced to a single principle, warding off harms. The idea that before engaging in an action, one must know its ethical and legal status applies to actions which are between an individual and his Lord, himself, or other individuals. It also applies to all matters religious and mundane. Muslim doctors are in need of fiqh, since all bioethical issues in Islam are subject to legal rulings with regards to permissibility, prohibition, and to determine religious etiquette and ethics. Jurists are in need of medical knowledge to arrive at the legal ruling for medical issues, as judgment depends upon how something is conceived. Areas where jurists are in need of medical knowledge include determining the harms and dangers of substances, determining whether an individual's condition warrants taking legal dispensations in matters of performing ritual purification, prayer, pilgrimage, fasting, and the like, as well as whether an individual is of sound mind and thus in need of having his transactions suspended, establishing paternity in certain circumstances, determining the perpetrator of a crime using forensic medicine or genetic fingerprinting, which is an area of contention right now, but it's an emerging topic, and also establishing the existence of a physical defect which can justify annulling a marriage contract. These are all matters that jurists are asked to decide upon, and all of these require input from doctors. So far we've seen that doctors need input from jurists need input from doctors. Emerging bioethical issues are in need of evaluation, which requires jurists and physicians. Physicians reveal the reality and details, and jurists formulate rulings based upon understanding. The past century has ushered in changes touching almost all aspects of life. Because of these changes, one encounters legal rulings in classical fiqh books that are couched in social circumstances that have changed, in which the mufti, the one offering the answer, and the mustafti, the one asking for an answer, okay, in the conditions which they exist. This situation is expected, as a legal principle warns that one cannot deny the changing of rulings in response to changes in time, place, people, and other circumstances. While legal analogy and basic legal methods can deal with some new cases, a classical basis is often elusive, and many new cases appear to be unprecedented, meaning that we do not have an immediate ruling for this new case. Currently, much work is being done to address how changes impact existing issues and how to respond to novel issues, especially when jurists do not find evidence relevant to the case in question. Much of this work takes place within the discussion of meta-level tools like the general objectives of the Sharia, the maqasid, as well as legal maxim, the qawa'id al-fiqhiyya. Changing and novel issues are actively researched by jurists, both individually and in groups. Since the earliest generations, religious knowledge has been considered a specialty which requires training and mentorship to achieve, like every other specialty, medicine included. The specialist they turn to for legal issues is known as a faqih or a jurist. A jurist explores legal evidence to extract rulings. Islamic legal knowledge is a collaborative project spanning centuries. Each generation of jurists works to evaluate, expand, organize, and otherwise improve upon the knowledge it received from their mentors and predecessors. This corpus of legal knowledge, what we call fiqh, is a result of applying the methods of jurisprudence to legal evidence to identify individual issues and their legal values. These methods of jurisprudence, or usul al-fiqh, enumerate the sources for legal rulings, their legal significance, tools for interpretation, how to assemble arguments, how to deal with outwardly contradictory claims, and what qualifications are required of a jurist. The primary sources of legal rulings which are accepted by the Sunni schools of law are the Quran, prophetic narrations, scholarly consensus, and legal analogy. The latter, legal analogy, is the primary mechanism for extending known laws to new cases. Individual schools also accept additional sources of law, though each school differs in which additional sources are valid and to what degree. The additional sources include the presumption of continuity, what's known as istishab al-hal, and the customs and habits which do not violate Islamic norms, and the consideration of public interests and facilitating the benefits and warding off harms. Also, prohibiting an otherwise lawful means because of its potential to lead to that which is prohibited, or permitting an otherwise unlawful means because of its potential sought-after benefits, and also what's known as juristic preference. Now, these last three fall under the general category of examining expected consequences, i'tibar al-ma'alat, which is particularly useful when a jurist applies a general ruling to a particular case. And based on the three things I mentioned, I know it was quick, it's also similar to what's done in like consequentialist reasoning and ethics. A short list of basic requirements for being a jurist includes being Muslim, legally responsible, and morally upright, possessing extensive knowledge of the verses of the Quran and prophetic accounts related to legal issues, a working knowledge of the Arabic used in textual evidence, and the customs prevalent at the period in which the Quran was revealed, knowing the principles of jurisprudence, legal analogy, and knowing areas of scholarly consensus and difference. Dr. Ali Muhyiddin al-Qaradaghi, a professor in Islamic law and legal methodologies at Qatar University, recommends a research methodology for investigating new bioethical issues. Now, the research methodology he's offering here is tailored specifically for this topic. And it's also predicated on the existence of a huge body of law and interpretation that it works with. So this is kind of a shortcut to try to get to answers here. And he developed this methodology because he has a large book about contemporary medical ethics and other issues dealing with medicine. And the basic gist of his methodology is this: to gain a detailed understanding of the issue and consulting with area specialists as needed. Then gathering the primary evidence and opinions related to the issue from the Quran, prophetic narrations, and areas of scholarly consensus, making use of commentaries on the Quran and narrations, the statements of the companions, their successors, making use of collections of narrations which include their statements and legal judgments, the musannafat, classic fiqh literature, including comprehensive texts, collections of fatwa, and region-specific rulings. It includes looking through the legal literature of the 4 extant Sunni schools, as well as the other schools. It also includes looking at the decisions, fatwa, and recommendations offered by fiqh councils for previous or similar cases, which we will be getting to in a moment. And it also includes looking at academic dissertations related to fiqh, conventional law, and Islamic economics. If nothing has been found after looking through all of these various sources of evidence or prepackaged ahkam from previous scholars, if nothing has been found, the researcher returns to the basic concepts: justice, benevolence, equity, and the basic legal maxims and default values, and implementing overall objectives of the Sharia. And if the researcher, after using these more meta-level and rational tools, still has not settled on a particular ruling, he begins the process again. And he will repeat this process over and over again, because this is a type of ijtihad, and ijtihad is defined as badlul wusa, going through all efforts, expending all energy you can to try to arrive at an answer. If he hasn't gotten the answer, then the assumption is he missed evidence. So he keeps repeating this. But if he keeps going at it and still can never find certainty on an answer, then he abstains from issuing a ruling and he admits, I do not know. That is the general process that Dr. al-Qazwini followed during his own research into bioethical issues. I mentioned earlier that the contemporary jurists work as individuals as well as in councils and a group. Fiqh councils were created to facilitate the evaluation of new issues by pooling the skills and knowledge of senior jurists and by drawing upon expertise from other fields. Consulting with experts from other fields, such as physicians and economists, provides jurists with more accurate information for their evaluation. The councils sometimes attempt to build consensus on existing legal issues and identify which of the acceptable opinions is most appropriate given the current circumstances. The opinions, decisions, and recommendations issued by a fiqh council are non-binding. This is a very important point for people to realize. The recommendations that are offered by IOMS, these are not binding. No person is obligated to follow them simply because they issued them. However, individual nations and institutions, public health institutions, can choose to adopt them as official policies, thus rendering them legally binding. Legally binding because an authority preferred that opinion, not legally binding because a fiqh council arrived at that decision. Muftis can also use fiqh council opinions as a basis for their own fatwa, though they should be reviewed before being applied outside the region where they were originally formulated. The major councils in the Arab world include the Islamic Research Council at Azhar University in Cairo, which was founded in 1961, the Islamic Fiqh Council and the Muslim World League, founded in Mecca in 1978, the Islamic Fiqh Academy, founded by the Organization of the Islamic Conference in Jeddah in 1981, the Islamic Organization for Medical Sciences, IOMS, which was founded in 1984. Similar councils exist in other parts of the Muslim world. For example, in the Indian subcontinent, Southeast Asia, they also have their boards and councils issuing opinions on similar topics. These fiqh councils have researched and discussed a wide variety of bioethical issues. So what are the results of the contemporary scholars? The contemporary jurists and fiqh councils have made great strides towards addressing contemporary bioethical issues. This can be seen in the variety of emerging issues they have considered, as well as lists of overall religious objectives of medicine and the development of professional codes of ethics. Although the codes of ethics and objectives of medicine were not on the list of things I was supposed to look at, I have not seen in English works on Islamic bioethics where people have brought this up. So I'd like to mention them. Jurists have discussed the overall religious objectives, the maqasid of medicine, and they say that they are the preservation of life, the body, its limbs, and considering the preservation of these things a necessity, warding off harms in everything which is harmful, the preservation of health and providing treatment, and enabling mankind to fulfill its role of stewardship. As far as professional ethics for physicians, the jurists have enumerated points which should appear in any professional code of medical ethics for Muslims. And the points include that the attending physician have knowledge, experience, and expertise in his medical profession. That he work in conformance to accepted standards, that he be sincere in his work, trustworthy, and protective of the rights of others, that he know the legal rulings, the Islamic legal rulings and ethical rulings associated with medicine and sickness, that he employ Islamic character and etiquette, including being mindful of Allah, showing humility towards Allah, his patient, and his colleagues, and being truthful and trustworthy, that he respect his chosen medical profession by increasing his own knowledge and staying current, as well as respecting the specialties of other physicians. It includes being dedicated to treat patients and to never refuse treatment except when legally justified, and to refrain from human testing or experimentation unless having first obtained prior consent, to abide by the laws and guidelines established by the local law, the medical board, or similar authorities, and to protect patient confidentiality. Many of these I know exist in Western or secular codes of professional conduct for doctors, so clearly there is some commonality here. Now, what about the issues that these people have gone through? Well, the individual jurists and fiqh councils have already discussed a very wide number of contemporary bioethical issues. Now, in this slide, I show a large list of things. Now, I pulled these out of a pamphlet that we studied at Dar al-Iftah, and these topics were pulled out of articles that my instructor had put in the newspaper during Ramadan. During Ramadan, they wanted him to talk about biomedical ethics. 30 days, approximately, 30 articles. I have another book by him that has 42, most of which are not here. So these 30, don't think that this is all they've done. This is nothing compared to what the others have. Genetic fingerprints. And by the way, the list here are things that were of interest to Juristconsults, to doctors, and to people in the streets. They might not be interest to Western bioethics, but they fall into the realm of Islamic bioethics. What are the issues that we had during Ramadan? Genetic fingerprints, animal and human cloning, artificial insemination, benefiting from aborted or superfluous embryos. Should I continue the list, or has everyone seen it? Is it enough? Because we're short on time. All right, it's a lot of stuff. I have time?
If you could go through one of the ones that you may think are unique to Islam or distinct
Distinct to Islam.
with the Muslims.
Abortion is, everyone has like things about abortion that's of a concern. Maybe the answer that Muslims give is different. There's some things, excuse me for it, like hymen restoration. All right, everyone's laughing here, but remember in places like Egypt, this could be a matter of life and death. Right? It might seem really silly to us in the West, but don't we have to take into account the local culture? The mufti has to worry about his stakeholder having risk to life and limb. Right? So that's one of the things that might be fairly unique to Islamic bioethics. Let's see. And by the way, the answers to some of these things might surprise you. When I look at how stem cell research is discussed in America, I'm really surprised at how like conservative and strict it is compared to what I would find in the Islamic bioethics things. Anyways, abortion, stem cell research, artificial insemination. Anyways, the whole list is there. We also had the person who put this together gave us a 150-page research paper he did just on human cloning. 150 pages. People probably don't think that there's 150 pages of Islamic bioethics. This is 150 pages on human cloning, and it included non-human cloning also. But this is 150 pages by someone who 10 years ago did a 3-volume book on narcotics and drugs, 3 volumes in Arabic. And it's extensive, and he was writing this, I think, in 92. So before most of us were interested in bioethics, this guy was already there. So there's a lot of stuff. The presentation so far concerns methodological and scholarly matters, but jurists also have a practical role in public society. In addition to the role as researchers and teachers of Islamic legal knowledge, individual jurists take on specific roles to serve the general public. Common roles include serving as judges and as muftis. A judge, or a qadi, is a jurist who has been appointed by the local political authority to resolve disputes, enforce contracts, protect rights, represent wards of the court, and other duties. A judge's decision is binding. It has to be followed. It has to be complied to, and the person can be compelled to do it. But the roles and responsibilities of judges are pretty much outside the scope of the current topic. A mufti is a jurist who answers questions individuals have about their daily lives. He may also provide special consultation to judges concerning difficult matters. And a fatwa is a jurist's response to an inquiry from the ruling, for the ruling concerning a particular event which has already happened or will happen. Not made up issues, but something that has already happened or is on the verge of happening. Very practical matters. The fatwa is the result of extracting the significant features of an event, identifying a corresponding legal issue in the legal corpus, and then evaluating its validity, whether the essential elements and conditions have been met, and then its consequences. A mufti is a jurisconsult acting in a particular capacity, and the conditions for the mufti are built upon the conditions of a jurist. However, given the mufti's responsibility of contextualization, general rulings, and facilitating the objectives of the Sharia, mufti should have extensive knowledge of the objectives of the Sharia and areas of differences between jurists, and be familiar with the customs and habits of the petitioner's society and the particular circumstances in which he lives. Now this last part about particular circumstances, it means that the findings of the fiqh councils and muftis over in the Middle East or some other foreign land, they might be great there and they might be good here, but they have to be evaluated ahead of time to make sure that none of the custom that went into that ruling is different than the custom here. Anyway. Now, as far as a process, Shaykh Ali Gumar, the current Grand Mufti of Egypt and the head of its Fatwa Institute, Dar al-Iftah, breaks this process into 4 stages. And he says that the steps are taswir, takyif, hukm and iftah, or conception, adaption, ruling, and then issuing the fatwa. And the stages of the process work like this. In the stage of conception, the petitioner describes an event and identifies the features of the event which are significant in determining a legal ruling. Based on my limited experience as being a patient, this is kind of like a doctor's consultation where you describe your symptoms and then he starts asking you more things, right? This is what's going on in taswir. The mufti, or the doctor, is trying to get all of the facts necessary to identify what is the problem. And that's what happens in takyif. The mufti identifies a known legal issue that corresponds to the described event. And then in the stage of legal evaluation, or hukm, the mufti checks whether the preconditions and essential elements and associated conditions for the identified issue have been met and its ensuing legal consequences. So for example, suppose someone asks about what is the ruling of getting an abortion. We've collected all of the facts. Well, in order for abortion to be permissible, it has to occur at a particular date or before a particular date. So if a mufti is asked about contextualizing and applying the general rule to a particular case, he looks what are all of the conditions that have to be met. So this is what happens in the hukm stage. And then after that, we get into the stage of response, or iftah, where the mufti then looks at the petitioner's particular circumstances to ensure that applying the ruling will realize the petitioner's interests and promote the objectives of the Sharia. So going back to the example of abortion, usually after 120 days, abortion is not permissible in this school. What if the mother's health is at risk? This particular detail changes everything, because preserving her life takes priority over preserving the child. And then in this final stage involves examining expected consequences. We mentioned this earlier, i'tibar al-ma'alat, which is an essential part of a jurist analysis, which unfortunately is often overlooked. Imam Shatibi discusses this subject in detail in his book Al-Muwafaqat, where he states that a jurist does not judge an action performed by a legally responsible individual, whether it is one of commission or omission, until he has first examined the action's resultant consequences. Now this is pretty important, because if we have multiple ahkam, we look at all of the possibilities, kind of what you do in policy analysis, right? So there's another tool that we can use when we want to get into bioethical rulings. I'm almost done. I'm done at the end.
Not getting ready. Don't be mad. 5 minutes.
All right. Today, most muftis are trained in a single school of law with some exposure to rulings from other schools and prominent scholars. Muftis tend to issue fatwa according to the soundest opinion in the school that they studied, although circumstances do sometimes warrant preferring a weaker opinion within that school or an opinion from outside the school together. Classical collections of legal rulings include numerous examples. By the way, this is a type of legal plurality, I think is the term you would use. Now, classical collections of legal rulings include numerous examples where scholars of a school acknowledge that circumstances prompt the school's legal scholars to apply a less stringent opinion to ensure that the overall objectives of Islam are met, namely warding off harms and facilitating public interest. Shafi scholars, for example, notice that there's a particular case where a wife, her husband has abandoned her. He cannot be found anywhere. He has not left any money for her to support herself. No one knows where he is. Really extreme circumstances. The soundest opinion in the madhab is that she's stuck. However, scholars in the school point out that if we follow the strongest opinion with respect to evidence, we will be denying rights and benefits that Islam aims as an objective to actually obtain. So this particular ruling, if we were to actually follow it, we would end up getting the opposite of what that ruling would produce had all of the circumstances been the way they were supposed to be. All right? The position I just said, you don't get to use it here. You have to ask a mufti before you can start using that opinion. It's just an example. And alhamdulillah, we have this example. But anyways, the Shafi madhab, what did the scholars do? The soundest opinion is X, but because of the circumstances, we all will use Y. We admit the other one is stronger. Necessity requires, and Islam requires, we go with what, as far as evidence goes, is weaker. So where were we? Institutes and organizations. All right, institutes and organizations often have institutional fatwa policies to address pressing social issues. This is particularly common for official government institutes like Dar al-Iftah, and this is out of acting in accordance to the legal principle that authorities, the actions and decisions of the authority, are to always be there to obtain public interests. In Arabic, we say tasarrufat al-imam manutun bil-masalih. So whatever the authority, whether he's the imam or who takes his place, his decisions are supposed to be there to make sure that the needs of the general public interests, that they are being met. So because of this, sometimes the authority gets to choose one opinion over the other. While classical fiqh books do provide a basis for answering many contemporary bioethical issues, legal research findings offered by contemporary individual jurists and fiqh councils also provide a source for iftah. There's some caveats here. It is important to remember that a fatwa is a non-binding legal opinion. The petitioner is under no obligation or compulsion to follow the mufti's opinion simply because he issued it. He's entitled to go look for another opinion. It is also important to keep in mind that fatwa are intended for individual consumption and that a mufti is not required to document his reasoning and evidence. He doesn't have to do this. One cannot assume that a fatwa found in a classic legal manual or a fatwa collection or yesterday's newspaper automatically applies to apparently similar situations. This presentation introduced the importance of knowing the ruling, the ahkam, for bioethical issues, the relationship between fiqh and medicine, and the need for jurists to investigate contemporary issues. It then presented the role of individual jurists and fiqh councils in investigating contemporary issues, and the need that this be done with collaboration for input from medical experts, and then provided examples of the progress made thus far. It closed with a brief introduction of how muftis apply general rulings to particular contexts. It also included a couple comments about establishing policy that could be used here. And my closing remark is that the substantial work of contemporary jurists and fiqh councils show that the perception that Islamic law cannot address contemporary realities and that Muslim jurists lack a methodology that allows them to engage in and produce viable solutions to contemporary bioethical issues does not match the facts on the ground and should no longer be an issue. Rather, benefiting from their research and inviting their participation should be part of future efforts. Thank you for your time. And I apologize to the next speaker for taking so much of his time.
Thank you very much, Sheikh Musa. Our final speaker is Imam Hassan al-Qazwini. Imam Hassan al-Qazwini is the leader of the Islamic Center of America, ICA, in Dearborn, Michigan, the largest mosque in North America. He is also founder and spiritual leader of one of the largest Muslim youth organizations in North America, the Young Muslim Association, YMA. Imam al-Qazwini was born in Karbala, Iraq. He studied for 12 years at the Islamic Seminary in Qom, Iran, with a focus on Islamic jurisprudence and Quranic commentary. During his studies, he administered the Islamic journal Al-Nibras and authored 2 books, Meditation on the Sahihain, a critique of Sahih al-Bukhari and Sahih Muslim, and a work entitled Prophet Muhammad, the Ethical Prospect. After the completion of his studies in 1992, he came to the U.S. and served as a teacher and scholar of religion prior to his arrival at the ICA in 1997. Imam al-Qazwini is a national figure in the Muslim community, has appeared on a number of media outlets, and has been invited to advise and consult with various members of government, including Congress, the U.S. State Department, as well as multiple presidents. He is most recently the author of American Crescent, a Muslim cleric on the power of his faith, the struggle against prejudice, and the future of Islam in America. It's our pleasure to invite Imam al-Qazwini. His presentation is entitled The Role of a Shiite Imam in Bioethical Consultations. Imam al-Qazwini.
My dear brothers and sisters, peace be with you. Assalamu alaikum. As an introduction to my presentation, I need to point out to the fact that the Muslim community is not a monolithic community. There are 1.5 billion Muslims around the world who are divided into so many sects and schools of thought. We often are asked by non-Muslims on what Islam says about this issue or that issue. Now the answer is, what Islam? There are many schools of thought, there are many sects, there are many denominations. Just as Christians, for example, are divided into so many denominations and sects, Muslims also are divided into so many schools of thought and sects. And therefore, difference of opinion is very, very common among Muslims, just as it is common between non-Muslims as well. But basically, Muslims are divided into 2 major schools of thought, the Shia and the Sunni. The Sunni school of thought is divided into the Hanafi, Shafi'i, Maliki, Hanbali. There are the Sufis, the Salafis. Also, there are some other groups who might not be necessarily 100% Sunni, such as the Ahiri and Abadi. In the Shia school of thought, we have the Zaydi, the Ismailis, and the Twelvers, the Ithna Ashiris. And it is also very common that you find difference of opinion between the scholars of the same sect and the same school of thought. The Shia community basically represent 20%, roughly 20% of the Muslim community in the United States and abroad. And they are therefore a minority within the minority. Their probably largest hubs are Los Angeles, where there is a huge Iranian community resides, and Detroit. And of course, Dearborn probably is their stronghold. Now, in regard to bioethical issues, there are two guiding principles that rule the fatwas of the Shia scholars regarding to the bioethical matters. The first guiding principle is Shia scholars do not believe in equality of life, meaning that it doesn't matter whether it is a fetus or an adult. The life of both individuals are respected and should be preserved. It doesn't matter whether it is in its vegetative state or it is in its productive state. The life of both individuals should be preserved. There is much emphasis in the Shia school of thought on the sanctity of life. And of course, that's derived from verses of the Quran and the tradition narrated by Muslims from the Holy Prophet and the 12 Imams who are the descendants of the Prophet. Shia scholars believe that there is no justification whatsoever in terminating any person's life. Therefore, for example, they take a very hard stand with abortion. They believe that all forms of abortion are prohibited and there is no justification for abortion. Probably the only situation that is deemed permissible is what my brother Shaykh Musa referred to, and that is when the life of the mother is in danger. So now you have to choose between two lives, the life of the mother and the life of the fetus. In this particular case, Shia scholars believe that the mother whose life is in danger then can abort the fetus. But other than that, Shia scholars do not tolerate terminating someone's life. The other guiding principle that rule in the bioethics, Shia bioethics, is that we have two types of predestination. And Dr. Jackson briefly alluded to that. From the Shia perspective, we believe that there is the definite predestination and indefinite predestination. Al-Qada al-Mahtum wal-Qada al-Mu'allaq. Definite predestination is like someone who is cancerous and he exhausted all means of treatment and there was no treatment whatsoever left for this person and he would die. This person will face death by God's predestination and he has no role, he has no hand in his death. For he exhausted all means to survive and he could not. So if he dies, it would be with God's will. So this is called the definite predestination. versus the indefinite predestination, in which the person himself has a role in choosing his own path. Dr. Jackson spoke about the Mu'tazilite and the Ash'arite, and I can safely say that in most examples and stances, the Shia attitude is similar to that of the Mu'tazilite. They believe in the human free will. They believe that the human person has a great role to contribute to his own predestination. So, for example, someone who is about to take 10 pills of Vicodin, he mostly will die if he does so. Then this person has a major role in his death. He cannot blame God for his death, because deciding for his death, it's a decision that falls in his own hand. He is deciding for his death. So the concept of predestination is loosely defined in the Shia school of thought, in a way that the person also has a role in deciding his fate. And I can elaborate on that, but because of the scope of the subject, I cannot go too far on explaining the concept of predestination from the Shia perspective. Now, I would like to go back to before talking about the role of the Shia Imam, I would like to talk briefly about the Shia perspective on bioethics. Based on these two guiding principles, the majority of the Shia scholars. Now, the reason I'm saying the majority of the Shia scholars, because I already mentioned that there are differences of opinion between the Shia scholars themselves. So when I talk here, I'm representing the perspective of the majority of the Shia scholars. The majority of Shia scholars believe that a person who is dying, the medical community has the responsibility to exhaust all means to save his or her life. Now, saving this person's life may require curing his sickness if the sickness is curable. But often, saving this life's person may not require curing his sickness, because there is no cure for his sickness. Rather, prolonging his life, even by days or even by hours. Shia scholars believe that the patient who has been told by his doctors that there is no cure for your sickness, doctors should do everything possible to prolong his life, because that's the implication or application of saving life to this person. Now, there will be one problem that many members of the medical community struggle with, and that's the concept of suffering. They say, what is the point behind prolonging someone's life who's going to die anyway? If there is no cure for this person, why do we have to do extra to save his life? They deem any attempt to preserve this person's life to be nothing but torture and adding to his or her suffering. Now, Shia scholars answer that suffering is not confined within the physical suffering. Suffering could be physical or could be spiritual. When doctors are trying to help this person die peacefully by removing him from the life support machine, all what they are doing, they are ensuring the end of his physical suffering, but they cannot ensure the end of his spiritual suffering. How do we know how his spirit is feeling now when we end his life? We do not know. This is beyond our real. This is beyond our grasp, our personal grasp. Therefore, we are not sure by ending this person's life who's suffering, we are doing him a favor by terminating his life. Therefore, Shia scholars believe that this person should be given the opportunity to live, even if that takes 1 day or 1 hour. This person should be put on life support machine. And it would be a sin for his relatives to agree on removing him from the machine if the removal from the machine would result in his immediate death. So this is something that many doctors, physicians struggle with today. And it puts the Shia individuals as well as Shia imams in an awkward position, because as I'm now talking about the role of the imam, Shia imam in regards to bioethical issues, I have to admit that I counter this issue on almost daily basis. I receive calls from the relatives of the patient who are telling me that the medical institution, be it a hospital or anything else, is pressuring them to remove this person from the life support machine. And they ask me on what their religious responsibility is. And of course, as a religious consultant, I have to lay out the case to them, and I have to inform them that they cannot agree on allowing this person to be removed from the life support machine. There is one thing I need to add in regard to brain dead cases. In most, or not most, probably in the majority of, I'm not sure indeed, I don't have an accurate statistic on that. In many US states, the rules and regulations consider a brain dead person to be dead. Therefore, this person is no longer entitled to receiving medical help. From a Shia perspective, someone who is diagnosed as brain dead is not dead. Death occurs only when it completely occurs when the heart stops and all signs of life stop. Therefore, this adds to the dilemma. When we have someone who is diagnosed as brain dead, we receive calls from the hospitals, often from the doctors themselves, or from the relatives of the patient, asking us on what do we say on this situation. I need to relate to them the fatwas of the Shia scholars. I have to tell them that from a Shia perspective, they cannot remove this person from the machine. I have to admit that there are a few Shia scholars who believe that someone who is diagnosed as brain dead is dead. And now we are dealing with the life of cells only. But the majority of Shia scholars reject that opinion. They believe this person is still alive. And therefore, the medical community has to strive to keep him on the machine. Now, this may take a few days, and if in a few cases it may take months, probably, if not years. Now, when I talk to the relatives of the patient, I explain their religious choices to them. I explain to them what the fatwa of the scholar is. And by the way, in the Shia school of thought, the fatwa, the edict of the scholar is binding for his followers. So if this marja, if this mujtahid, jurist, this scholar believes in such thing, his followers, those who follow him on his edicts, they have no choice but to abide by his rules and fatwas. So that is in one scenario where the imam, the Shia imam, is involved in relating to the family of the patient the fatwa of the mujtahid, and basically explaining to them and to the medical community what the religious verdict is on that issue. Of course, the second role the imam plays is it's an advocacy role, explaining and implementing the ethical paradigm of the Shia school of thought. The imams play a major role in advocating on behalf of the patient and their relatives, advocate their position to the medical community and to circles interested on bioethics. Therefore, it is the imams and religious institutions who basically take that role. And that's why, for example, I'm speaking today here, because I'm supposed to represent the religious interest of my community as well. Now, the third role that the imam plays, it is a reference role, being a resource and a reference for staff for development of hospital policy. So in this role, the imam, again, he plays the role of the reference, in which he is contacted by hospitals, by universities, to determine where the Shia community stands on bioethics. And lastly, the imam plays a comfort role on comforting the person going through end of life and their families, so as to safeguard them from inappropriate decision making. Many people call me and I have to direct them to the right direction, because we believe that a practicing Muslim should follow the rulings of his faith. Therefore, when they call me, I am morally obligated to explain to them what is right and what is wrong. Whether they take it or not, that's their choice. Whether the hospital gives a margin of freedom to them to exercise their faith or not, that's their problem. But my responsibility is to make sure that I explain to my congregation and to my community what is moral, what is right, and what is wrong from an Islamic Shia perspective. So basically, these are four basic steps that the Imam takes as he is exercising his role in the bioethics issue and end-of-life issues. Thank you so much. God bless you. Wassalamu alaikum wa rahmatullah.
Thank you very much for that, Imam al-Qazwini. So, as is appropriate, I'll begin by apologizing for cutting our first speaker short, not giving him the time that was his due. I'm sure that I'll be apologizing even after this and making it clear to him that my doing so was not out of any personal disinclination towards hearing the remainder of his comments, but rather because of my own confusion as to the amount of time allotted to each speaker. A confusion which was clarified after he finished his discourse. So what I think we'd like to do just before we start, what I expect to be a very fertile and beneficial session of question and answers, is just to give him another 3 minutes, if you'll take it, in order to elaborate on your theme or Or do you think that those issues will come out during the course of the Q&A, and we should just start that immediately?
Hopefully, and I don't want to cause any more confusion than I probably already have, so
No, not
I'll
at
just
all.
wait for the questions.
Oh, yes. Okay, so just to remind ourselves so we can situate our questions very well. So we had a very elucidative and helpful presentation from Professor Jackson about really the meta-ethical schools and trends that existed in the Sunni ethical legal tradition, with the clear indication being that the difference and diversity to be found there has something to say about how it is that jurists acting in the contemporary space may differ and how they differ and what are the bases of their differences. And then we had a very elucidative and very helpful presentation from Shaykh Musa Furber on the meta-ethical principles and precepts and methodologies that are used by individuals and even perhaps in some way more importantly by juridical councils, by collective Juristconsults, that clarified for us not only that there are methodologies in place, but that there is a fair amount of literature that has actually been produced, and that someone who's active in the space, whether they're a jurisconsult active in the space or they're an academic reflecting as an observer on the activity of jurisconsults, isn't starting from scratch. There's a fair body of information for them to reflect on. And finally, we had a very helpful and I think very personal description of the role that an imam plays in the pastoral and advocacy of the concerns of the Shiite community. And many, of course, his descriptions apply more generally to religious counselors in general. And with that, please let's open up. We have two mics here. If you just come down and line up, and then we're going to, or you can raise your hands, I'm sure, from where you're seated, but it would be easier if you spoke on the mic. That way we can hear you. Yeah, so actually you have to come down to the mic so that we can hear you and have you recorded. Okay? We'll start here and then alternate. Please.
Thank you. I want to thank the organizers and the panel for such a enlightening talk. My particular question was going to focus a little bit on Imam Qazwini's discussion regarding the responsibilities of providers to do whatever is necessary to prolong the life of an individual. And I assume that also means to potentially prolong or do whatever is necessary in order to keep an organ going, not just a life going. And my question is, how does that compare from an ethical perspective when we look at our responsibilities as stewards of limited resources from society's perspective? We don't have an unlimited financial or personnel to keep everything going as long as it's possible. How does that balance with the feeling that we need to do whatever is necessary to treat individuals?
I'm supposed to. Yes. Well, thank you, Dr. Imami. By the way, Dr. Imami is my doctor as well. So I hope you take care of me, Doctor, if something happens. And you do. So, well, it's a good question. When we have limited resources in our hospitals, we have beds that are much needed by other patients. What do we do here? I think that this is one of the probably dilemmas we're facing. Shia scholars insist that a brain dead person, for example, is not dead. He's still alive. So to remove him and put another person in his place is an earned judgment. And therefore, they have a problem with the concept of favoring one person over another. Now, I have to say one thing, and this is my own personal feeling, and I hope I'm not offending anyone. I personally feel that the motive in some hospitals to remove this person from his bed and to tell his family members that there's someone else need to take, it's somewhat might not be very objective. It is, I would say, it is benefit or profit-based industry. You know, insurance companies struggle to pay for the patient, and when they see someone staying in the hospital for 7-8 months and he's not so productive, they may not be interested in pursuing that route of keeping him on the machine. So I believe that sometime our human interest also play a role in making decision for these patients. So I feel that the issue should be addressed morally and objectively, without having to deal with insurance companies not being so willing to spend more money on someone who is not deemed so productive. But I agree with Dr. Imami that it is a moral predicament when we have limited resources and we cannot do much about this case. I agree with you, Doctor.
Yes, please.
Yes, Assalamu alaikum. Thank you all for your presentations and insight. I hate to be the one to open the Pandora box of gender issues, but there was a participant earlier who asked that question first to Professor Fisher. I was in ICU in my 4th year of medical rotations once, and there's an 80-year-old Egyptian woman who was intubated and was terminal. I became the subject of quite a bit of scrutiny when the staff and the nurses found out that that patient has had genital mutilation. My question for you, whether you're dealing with theological ethics or the survey of the juristic procedure, is they are, and my friends like Hamada here will immediately counter that this is not a problem that's prevalent. It is not, but it has a tradition that might have survived for tribal reasons or in certain tribal settings. Nevertheless, it was accepted in many different African and other tribal cultures by Muslims. My question is, why is it that we don't see, or at least publicly, a critique of the reasoning and principles that goes into an outcome of that sort of an opinion? Thank you. Or this could be actually any of you.
Wow. Correct me if I'm wrong in understanding this. You would like to know why there's no criticism of the practice and the principles and all of that?
I'd like to know why there's no criticism of the reason or the principle that we're trying to reach to that conclusion. Because it seems like when you said that, if opinion Y, opinion X is not good, we'll move to opinion Y in terms of public interest. But that's teleological, that's goal. So what about the jurists who accepted that opinion that allowed them to reach the issue? What principles of that?
Okay, first of all, when you want to, I'm not sure this is the proper venue to get into such a heated topic, but since you brought it up, you must be aware that female genital mutilation has what, 4 different types? Which type is the thing that Islam recognized as possibly having a source? Which type? Okay, they say 4 different types. One is just removing a little bit of the clitoral hood. Another opinion is removing a little bit of the clitoris with it. Another one is excising the clitoris. The next one goes even worse. Which one are we talking about here? Because only one of those has a basis in the Sunnah. And everything above that has been declared a criminal activity in Egypt more than once. This is not something where the ulama have remained silent. When I was working at Dar al-Iftah, I think in 2007 or 2007, there was a huge conference about this particular issue. A huge conference where they went over what is the basis for this. Is there any medical benefit from it? Is there any harm from it? They looked through it from all different angles. This was one conference. This is one conference among many and one opportunity amongst many where the ulama have talked about this. if there is a perception here that they remain silent, remember in the last comment I made that, and they've been talking about this stuff, maybe we should listen. Maybe we should be seeing what they say, because they have talked about this. And starting out with a position, they've said nothing. We hear this living over there. I hear so many times Muslims here saying the ulama are silent. The ulama are talking. They're talking many things. Sorry, I don't use English all the time. There's a huge quantity of talk that they've done about the same things that you're interested in. No one bothers to go look. In the Arab world, the ulama are speaking in Arabic and writing in Arabic. Learn Arabic and then see what they've done. But if you don't even have the ability to go look and see what they've done and know where they would have done it, you can't come up with a judgment. They're silent on this and they're not speaking. And I know that some of the books about Islamic bioethics and Muslim bioethics have talked about the criminalization of this act. And they have talked about the differences of opinion about the Islamic basis of this act. So I'm sorry, the onus is on us for not going and doing research. And I'm sorry if this sounds like a personal attack, but how many times do we see people saying the ulama didn't say anything? And it's right in front of their face, but they won't look at it. You want to know an answer? Do the research.
Jackson? Yes.
Hello, good afternoon. My comment, I guess, follows along with that, and it relates to the both panel presentations. As Muslims, we believe that Islam is mostly based on the Quran, which is God's words, and prophetic tradition. As such, it follows that many answers to questions of ethics can be found there. And given such a premise, it follows that obtaining sound positions about the areas of bioethics would benefit the West, and the East from these Islamic positions and viewpoints. And they would also serve to help resolve some controversies, vague, varied, circumstantial, or conditional though they may be. I guess my questions are, one, how do we go about presenting the richness of Islam for reference and guidance to answer such circumcision-type questions? And the other is, how do we go about researching, soliciting, and presenting this Islamic information in the current political anti-Sharia environment in the U.S. and in the West in general? I've read, many bioethics books, and the Islamic position to end of life, suffering, abortion is never presented. And I think that it would be not necessarily an accepted position by all, but at least an element for consideration. Thank you.
So I have to now, I guess.
Well, I don't know very much about the mechanics of how we would go about greater diffusion of Islamic knowledge in an American setting. Two things that come to mind, however, is that I think that among Muslims themselves, there's a need for greater diffusion of just basic Islamic literacy, because I think that oftentimes what happens is people, or particularly Muslims, often fall back on what is sort of culturally acceptable, or what is culturally known, or what simply has the accumulated authority of historical practice in a particular place or time. And that is often taken to be the full expanse of what Islam has to say or to offer on an issue. I think that to the extent that Muslims can become more familiarized with their own tradition, and they can be more effective in bringing others into an understanding of just how rich that tradition is. On another level, however, I think that, your question is quintessentially, in this particular environment, it's political. And I think that, in fact, non-Muslims in America really do have to recognize how much is being lost by the silencing or the intimidation. And lots of that is going on, however surreptitiously it may be taking effect. But the silencing and intimidation of Muslims who are Americans themselves, this is a part of our collective resources. I think the case has to be made for just how much is being lost by not having Muslims in a position where they feel that they can speak up and do so without recrimination. And what's at stake here is not simply the Muslim community, but America itself.
I would like to add to that is there are two other ways also to promote Islamic awareness. One is by cloning Dr. Jackson. He is a wonderful advocate and advocate of Islamic teachings and Islamic civilization. And he's a wonderful professor. We need to encourage our youth also to be enrolling in Islamic studies in major American universities, so they can be in a position where they can teach and promote Islamic awareness in the academic circles or in the public life. Also, I would like to point out that the conference, this particular conference, and I would like to thank Dr. Shanawani, holding these kind of conferences would definitely help promote that cause. This has been long overdue, having a conference like this, Bioethics, Islamic Bioethics, has been long overdue. So I think by having these kind of conferences and seminars, we may be able to achieve that goal as well.
So a couple of more minutes. I'm sure we're going to get through everyone, but...
Okay, my question is for both Shiite and Sunni Imam. What is the perspective on organ and tissue donation, specifically giving of organs and tissues, and then on the reverse end, being able to receive organs and tissues?
The Shia perspective on that is organ and tissue donation, organ donation in general, is permissible and even encouraged based on two criteria. One, during the life of the donor, the organ has to be internal, not external. So for example, a person cannot donate one of his two eyes if he is alive, during his life. The other condition is the organ, the life of the donor should not be based on that organ. So for example, no living person has the right to donate his heart while he's alive, because my life is dependent on my heart. With these two criteria, we realize that other organs are permissible. For example, kidney, which is internal, and one of the kidneys, my life is not dependent on both, rather on one. Afterlife, scholars, Shia scholars believe that with the consent of the deceased, in his written or verbal will, his organs could be donated after his life. In other words, the family members have no right to donate the organs of the deceased. Rather, it has to be with a clear, either verbal or written will of the deceased that he is willing to donate his organs to others. Now, there are some Shia scholars who believe that the recipient should be Muslim, but there are many other Shia scholars who believe that the religion doesn't matter here as long as it is with the will of the donor.
Okay, before we go to the Sunni follow-up question, how would organ donation work if doing a terminal wean is prohibited and brain death is prohibited within Islam? The two types of organ donation are donation after brain death and donation after cardiac death, in which there's typically a planned terminal wean, and if the patient expires within a set time frame, then you can recover organs.
This is one area where Sunni scholars not only tend to differ with our Shiite colleagues, but we also differ amongst ourselves about whether brain death is a criteria for death or whether the cessation of the pulmonary system is the criteria for death. So there is a difference of opinion amongst the scholars over which criteria we're going to use. If this is for like a research piece that you're doing, I would feel very happy to pull out some information for you so that you have very specific answers. But off the top of my head, I cannot tell you who said each one and give you all of the details because of the difference of opinion. If you allow me, I'd like to add 1 or 2 points to what the Imam said. One thing is that the Sunni scholars pretty much agree with what he detailed. But there's 2 things I'd like to add. One of the things we look at is organs that regenerate. For example, your skin. This is one of those things where we consider it's a much easier case to donate. And another thing we take into consideration is that there cannot be money involved as the incentive for the donation. And the worry here is that without this, it will lead to a gray or black market in organ donation. And so those are some additional criteria that the Sunnis tend to add on that issue.
Okay. And I don't know if there was a response from you about how exactly organ donation would work.
How exactly would it work?
With the patient after brain death or cardiac death, from either one of you. I mean, that comes down to, I guess, the practicality of it.
Will you be here tomorrow?
I will, yes.
Since we're going to, I think we're dealing with this particular issue tomorrow, I would prefer to maybe do some research for you tonight. And if I can, I'll try to give you a better answer.
You certainly don't have to, but that would be great. Thank you.
It would be my pleasure.
Assalamu alaikum. First of all, thank you to all our speakers, and thank you, Imam Qazwini, for elaborating on the Shiite position on brain death in detail. Just regarding the 2 other speakers, what is the, I think you commented on the Sunni position on brain death, that it's diverse, there's not one strongest opinion. But in addition to that, what is the position regarding life support, especially in light of maintaining dignity of patient, especially when they're in a position of, again, likely being in a vegetative state, non-recovery, and so on? What is recommended when dealing with the maqasid of the Sharia in terms of maintaining dignity of life over quantity of life?
This is one of the topics we are addressing tomorrow, and I think because of economy of time, it would be best for everyone if we defer that issue until tomorrow.
A practical question from an internist, general medical internist, who has patients in her practice who are Muslim, and that would be if a patient is facing definite predestination with a terminal cancer and is Shiite, would they have the opportunity to choose hospice? And if they did so choose, would their families be allowed to go along with that?
I'm not really well acquainted with what exactly hospice does. What I understand is it is kind of healthcare that they offer at homes. But I guess, you may enlighten me in that, I guess that there is no substantial cure other than just probably the
comfort care.
Comfort care. Well, Shia scholars believe that the medical staff has to exhaust all means possible, anything within their disposal to save the life of the patient. If hospice does that, then it would be okay to remove him to hospice. If the services offered by hospice does not include exhausting all means of saving the life of the patient.
Does not.
Does not?
No.
Then he should stay at the hospital.
This question for Mr. Furber about this thing, I think, correct me if I'm wrong, that you mentioned that when a fatwa is given, Mufti cannot be asked to give the reasoning or sources of his information of fatwa. Is that true? And if it is that the case, if a Mufti gives a fatwa and let's say I'm asking a question and I'm not comfortable, and how do I know the soundness of the judgment of the fatwa that he's giving? Like President Reagan used to say, trust but verify. And I like to verify, and as an educated person, that the the soundness of the information that he has giving us, it's appropriate and makes sense. And if we just don't do that, don't check it, that as you know, there are many young muftis and 25 years old giving fatwas around. It can have a lot of impact, especially if they have no medical knowledge and giving fatwas on the medical issues, which are very critical, and is happening in the practical life.
I may have just misunderstood what you said, but I know that during the presentation I said that a mufti is not required to give it. He is not required to clarify his reasoning. This doesn't mean that he doesn't ever do it, and it also doesn't mean that the mustafti doesn't have an opportunity to ask for that reasoning to be clarified. I know that there's a huge problem right now with muftis giving positions without clarifying the reasoning. If they don't clarify it, this is off the record kind of. Look, if they don't clarify it, go elsewhere, please. Darul Ifta al-Misriya, they offer a fatwa service in English. And if you ask them what is the evidence, they will give you part of the reasoning. They will not do the entire research project for you, but they will at least give you the main points of the reasoning that goes into generating that fatwa. Also, big institutes like Darul Ifta, they almost always have either large fatwa or research pieces which clarify the reasoning. And many times, if you ask for a question like on brain death, they'll give you the answer, and then they'll tell you which fatwa to go look at for further information. Again, if they're not giving you, if they absolutely refuse to give you their reasoning, please shop elsewhere.
And I would just like to make a comment about the issue that you're going to discuss tomorrow about the brain death. It's a very major and most controversial issue in the medicine today, about what is to be, in fact, the definition of death. This is a very controversial issue in the Jewish community, Christianity, and Islam. And we are a little bit lagging behind in trying to make the definition clear. And when this brain death issue was decided as the death, this was almost like 30 years ago when there was a shortage of the organs, and the unified definition of the Death Act, which was passed some years ago and ratified again 2-3 times. According to that, either brain or other is considered one of them is enough. But in actual fact, you need both of them to declare the actual death of the person, which is the oldest criteria. And this brain death criteria has been used only for one purpose, and that is to increase the supply of the organs of the heart, or the other, the body organs for the donation and transplantation. So it's a very touchy, very difficult issue in medical field as when to define death in the philosophical way and in the practical way. And one comment that in relation to the very first question that came up, that when you mentioned that if you want an answer, go do research. I think this is, in my opinion, a slightly difficult issue to handle because not everybody is into the research mode, and some information which has a critical impact on the community should be volunteered by the scholars in a little bit simplified version, and more often conferences should be held and disseminate the information rather than having the person to wait for do the research, and that will be only few people can do it. The majority will be still left without the information. Right. So I appreciate if there are more educational meetings to promote the interest of learning.
As far as my answer to the first question, I do apologize if I was so short and abrupt and blunt on that one. Part of the reason that it kind of generated my response is that this is an issue where, yes, there's controversy, and it has been discussed for and against on the internet everywhere. And I'm somewhat shocked that people will Google trivial things and they won't Google this. I mean, on this one, there's really not much of an excuse not to at least know the different types of female genital mutilation. I mean, to ask the question on this and to accuse the ulama of remaining silent on something that clearly is a problem, it kind of ticked me off. All right? And I do apologize. I do apologize for the tone, but I think that anyone who has sat on this side right now has felt that frustration, where the ulama are accused of negligence when they actually have been going at it 24/7, 365 and dealing with these things. I know that Darul Ifta both before Shaykh Ali and before his predecessor, since I think either the 60s or the 70s, they were all involved with the legislation that declared this a criminal act. There's no short history here on the ulama discussing this issue. So, again, I apologize. Please, on Yawm al-Qiyamah, don't ask for my flesh from this one.
Just a very, very short addendum. I mean, this is part of what I had in mind in terms of the real need, particularly in Muslim communities, for more literacy, because there has to be a higher degree, even when the ulama speak. Oftentimes, it's like throwing seeds on concrete, because there's not the capacity to really intelligently consume what they have to say, and therefore the tendency is to opt for the easy, pat answers. So I think that this whole enterprise of the greater diffusion of literacy is extremely important, and I think that for particularly those of us who live in America, we have the resources, we have the opportunity, we have even the burgeoning infrastructure. I mean, this is something I think that we really need to do a much better job of. Coming generations should be much more religiously literate than past generations, particularly here in America. And I think that this will speak, to some extent at least, to part of the problem that Sheikh Musa is talking about.
And I'm sorry, I just need to add one more. I think what the Shaykh meant by research, he really didn't mean that you go and conduct a scientific research, because that might be beyond the scope of your expertise. I think he meant the research on the internet, for example, which is very affordable and easy these days.
I think we have time for one more question.
Assalamu alaikum. I have a question specifically for Imam Qazwini and Shaykh Furber. I'm a head and neck surgical oncologist here at the university, and so we deal with a lot of terminally ill patients and a lot of end-of-life issues. And I think when we talk about bioethics, we focus a lot on the role of the healthcare provider, but there's also the perspective of the patient as well. So, I mean, each of them have their own specific issues. So in dealing with, let's say, an elderly patient who has a terminal illness, and we know that they're incurable, often when they're admitted to hospital, they're given the option of a DNR, or do not resuscitate, or do not intubate. So if they have cardiac arrest while they're in hospital, if they don't wish to have that done, then they would just be let go peacefully, their own way. So what, according to, given the sanctity of life, and given the Islamic legal framework, is there a role for the concept of autonomy for Muslim patients to want to die naturally in that kind of case? Is it permissible for Muslim patients to even request a do not resuscitate kind of order or request?
From an Islamic Shia perspective, if the patient is a practicing Muslim, he might not be a practicing Muslim, and therefore he will decide for himself. But if he is a practicing Muslim, then he should follow the fatwa, the edict of the scholar he follows, and he believes in his fatwa. So whatever his fatwa is, he has to follow it. Now, I mentioned earlier that the majority of Shia scholars believe that the patient should be put on life support machines, and he should not sign on a paper that indicates his refusal of the life support. But there are a few Shia scholars who believe that it is up to the patient to do that. So it is based on the scholar he follows, and the concept of taqleed, following the scholar on his fatwa, is very common in the Shia tradition. Most Shia practicing people they pick a scholar and they stick to his binding rulings. So it depends on the scholar he is following. If he follows a scholar who permits him, then he can reject the life support. if he follows a scholar who would not permit him, then he cannot.
There's several issues here. And one of the issues is, does the patient have to seek medical treatment? There's another issue. Does a care provider have to offer it, even if he's not being asked to do it? There's another issue of, can the care provider actively, how do we put it, quicken the person's death? Now, all of these are pretty, the first one, the general answer is no. Someone who's sick does not have to does not have to seek treatment. It's not something that is absolutely obligatory for him to do. And there is some difference among the scholars on this one. Very, very common position, he's not required to do it. Does the doctor have to provide? All things being equal, he's supposed to. If the patient, however, says that my life is forfeit, then the doctor would not be held negligent, would not be considered criminally negligent in the Sharia for, how do we put this, assisting in quicker termination of the life. Right? And please keep in mind the things I'm saying here, do not go apply them right now. You need to talk to someone bigger than me to make sure that the situation is right. But it's there. The final thing was the hastening of death. I mentioned there's some mechanisms that might allow it. Right? It's a very, very difficult thing. And I remember when I was talking to Asim about this, I think that a lot of the fuqaha, a lot of the jurists that look at biomedical issues do look at it a little bit too much like in the abstract and don't always recognize the position that an attending physician is put in, where they do see the suffering and they do want to know, can we allow the person to die? Can we quicken the death? What's going to happen? These are all complicated, and I know I keep saying let's defer this till tomorrow, but one thing that was on that slide that I showed you of all of those issues was the issue of removing life support assistance. One of the very common answers among Sunni scholars is that we cannot cause death, that the physician is not supposed to cause death to come faster. He's not supposed to actually actively cause the death. However, they can remove life support system. That is the only thing between him and his natural death occurring. But they make it as like, they try to comfort him when he does it. I'm not fully prepared for answering that question. That's for tomorrow, inshallah. But that's all I can give you at the moment. And it's, inshallah, alhamdulillah.